the Appellate Division, 4th Department. Hear ye, all persons having business to be before this court will draw near and give their attendance and it shall be heard.
Please be seated. First of all, let me start before I call the first case by apologizing for how warm it is in here. We are working on it, and I'm told that within the next half an hour or so, I'm not sure what the or so means, that we're going to have the system up and running, and but there's not much we can do about it. We're going to just have to kind of bear with it. So thank you for your patience. The first case on for argument today is case 423, People versus Ernst.
What about
Oh, which one did I miss?
420?
420 is submitted.
Oh, I'm sorry.
423, People versus Ernst.
Oh, here's the
May it please the court.
Mr. Hillary, if you wouldn't mind, just 1 second, please. Thank you. I appreciate that. Counsel, can you hear us?
Yes, Your Honor.
You're going to need to raise your volume. You're coming through, but very low.
Okay, thank you, Your Honor.
Try it again. Raise it a little bit. Or get closer to the microphone, one of the two.
I'll just come closer to the microphone.
Yeah, when you're closer to the microphone, it's going to be fine.
Okay.
All right, very good. Counsel, proceed.
Thank you, Your Honor. May it please the court. Michael Hillary for the people. Judge, the court wrongly dismissed this indictment for two principal reasons. Your Honors, those two principal reasons were these. Number one, the people were unfairly charged with some 200 days of unresolved defense-initiated motion practice. And the second reason was that the defendant failed to comply with CPL 24550 in that he did not move against the people's certificate of compliance as soon as practicable. It bears repeating, the people's position with respect to the challenge discovery materials, those welfare check materials, was announced in writing to the court and to counsel as early as July 13th of 2023. That was in response to the defense omnibus motion of, I believe it was April 25th of 2023.
And that first response was what again, Mr. Hillary?
That first response was that the materials that are at issue here were not relevant.
Right, but and the defense's theory all along as it relates to these materials is they'll show that the subject children were not in proximity to the events that led to the charges.
They would show, yes, Your Honor, they would show that the children were not harmed, that on the day of the welfare check, which was about a day and a half after the
I understand that point, but but at the same time, when the initial COC was filed, JK, I'll use the initials, JK was identified as a potential witness.
That's correct.
And the only thing that JK could have testified to, since she wasn't there, was the children's reactions after the event, correct?
That's correct. Yeah, and this gives me an opportunity.
So isn't that exactly what the body cam footage would have also shown?
Well, it's unclear what it would have shown. It purportedly would have shown that the children were at least not physically harmed. This gives me an opportunity to address to the court what I'm not addressing and arguing, which is that these materials were irrelevant. Now, I understand my colleague's position with respect to that. I understand their reasoning. Endangering the welfare is not a results-based crime. In other words, what happened after the fact would not have invalidated an attempt to prove endangering 2 days before. So I'm not contesting that the material was relevant. I think there's a good argument. I think Mr. Texito makes the argument that it was relevant. My position is a very narrow one here, that the people announced their position with respect to that, right or wrong. They in good faith took a position with respect to that material that it was not relevant. And defense counsel, instead of seeking judicial intervention when he had the opportunity, did not get it. He signaled to the court and to counsel that this could be worked out over a period of time, that he didn't anticipate there would be any need for judicial intervention. And not until a year later, almost a year later, did defense counsel move against the people's certificate of compliance.
Just to clarify though, but his position is that all along I was told there is no body cam footage. It wasn't until the day before trial when defense counsel got the FOIL response and got some information that there had been some body cam footage actual proof. I mean, do you deny or confirm that before the court at least, the people's position was there was no footage to disclose?
I believe the people believe that because based upon their multiple requests to West Seneca Police, they received nothing. The only indication that existed of any extant materials related to a CAD report, which is the item that was not disclosed, which was the item that Mr. Texito received via FOIL. The people believe there was no material because they had directly inquired of West Seneca Police. They had received all of the crime analysis materials early on in the investigation, and they had enlisted the services of one of our own confidential investigators to determine whether or not there was outstanding material. That gave rise to the existence of a CAD report. So the people were in good faith in suggesting that there's no material. Now, interesting to note, Mr. Texito, I want to say this right from the get-go so there's no misunderstanding. Mr. Texito did a fine job on behalf of his client. And he is an effective, intelligent advocate. I personally know him to be that. So I'm not assailing the credibility of Mr. Texito. But what I am saying is, Mr. Texito does submit in his response that despite the people's representation that no such material existed, he quote unquote knew it did, and yet did not move for resolution of this contested issue through judicial intervention. That should not be charged to the people. If the people take a good faith position, having investigated the matter, and yet take a good faith, albeit probably incorrect, that the materials were irrelevant, they've announced it to court and counsel, they're not hiding anything, then it's up to a defendant through his counsel to see if the people are continuing to be at an impasse with him on this material to get a judicial remedy. And he simply did not do that. Rather than do that, he waited until jury selection to bring an oral and submit a written motion to dismiss. And now the effect on the people's case is catastrophic. And I simply think, given the fact that this was an open issue, as even the court that decided this motion indicated on the day that the dismissal motion was brought, it said, these are outstanding. These issues are still outstanding. Right? So that signals that this was an unresolved motion.
When was that? Remind me of that.
That would have been the court said that May 8th of 2024.
And that was with the Supreme Court judge who ultimately decided the case?
Yes. Prior to doing so, that court said that this discovery issue is quote unquote outstanding.
It could only be outstanding if the motion wasn't withdrawn, correct?
Yes, Your Honor.
So your position is Mr. Texito did not withdraw his motion, therefore was still under consideration.
That's correct, Your Honor.
And Mr. Texito essentially said on the record, as I'm looking at it, that we'll let you know if we have a problem and we'll come back.
That's correct, Your
But
Honor.
that didn't withdraw the motion, did it?
I don't believe it did. Your Honor.
And that answers the speedy trial issue right there if we were to agree with that argument.
I believe it does, Your Honor.
So your argument is the people had no obligation, no burden to get a decision from the court on that ruling.
It wasn't the people's motion. Now, might the people have pursued? I suppose they could have. And they could have assisted defense counsel, but their position all along was this isn't relevant. The defendant's position was this is relevant and admissible and goes to disprove the charge here, or at least it goes to assail the credibility of one of the people's primary witnesses. It's the defendant's wherewithal at that point to seek a judicial remedy, especially when he signals to the people, well, we can work it out. Now, it was not lost on anybody that there was an impasse that lasted several months. And so when you look at the record from, a 30,000-foot view, it appears that defense counsel, and to his credit, defense counsel is embarking on a campaign of a conciliatory campaign of trying to work it out with the people. But it should not have been lost on him throughout that period that the people's position had not changed. The people did not waver. He did not suggest, oh yeah, maybe it is relevant. Maybe we'll turn it over at some point if we can find it. The people's position always was it wasn't relevant. Now, again, I'm not arguing that it wasn't relevant. I'm simply arguing that when the people in good faith declare a position on contested discovery, upon a motion by the defendant for that discovery, the defendant is required to seek the necessary judicial intervention to determine that motion if there's an impasse, and that just didn't happen here.
So just remind me again of the record, what did the court do with the motion? When the lawyers left the courtroom, what had the court done with that motion?
Judge, are you referring to the May 8th?
The Huntley?
Oh, the Huntley, I'm sorry. So there were outstanding issues at that point, and the court addressed to defense counsel whether or not he wished any return date so they can come back and see whether or not these issues had been resolved. And in response to that suggestion by the court, Mr. Texedo said that that won't be necessary unless there's an issue, we'll try to work it out. I'm paraphrasing, but he said, there's no need for judicial intervention at this point. In fact, at that point, the court brought up trial date.
So did the attorneys then understand that the motion had been withdrawn? It wasn't a pending motion?
I don't know I can't say what was in Mr. Texedo's mind, but there's
Just the record.
the record does not say it was
The lawyers were not pursuing
right.
that, so the no longer was a motion before the court?
I don't read it that way, Your Honor. In fact, my argument is to the contrary. My argument is it is a motion that the defense counsel made that he is attempting to resolve by other means at that point, other than judicial intervention, but that judicial intervention remains a ready solution. All defendant has to do is request it. The court announced to him, if you need judicial intervention, simply ask for it. I can have this called back anytime. So it wasn't really, I can't consider this to be a withdrawn motion. It's still open. And even the court of record on this decision indicated it was quote unquote an outstanding issue.
So you could have at that time, not you, of course, but the people could have at that time said, Your Honor, we want to resolve this here for now, and we need a ruling on the Huntley. We need a ruling from the court so that we know that that's foreclosed and we can move forward.
The people could have done that. They could have done that. My only argument there is that they weren't required to. It's defendant's motion. If their position is, you know what, this
But
is
the
not
people are
relevant.
concerned about 30-30 all the time.
Yes,
And that's certainly part of the calculation on a 30-30.
yes, Your Honor.
Wouldn't the people in protecting their own case and their rights say, hold on a second, we need a resolution of this?
Well, if they believe that the motion is still open, I don't think they would necessarily think that way. If they think that this is just a matter of, okay, the motion is open indefinitely, pending some extrajudicial resolution by counsel, then there wouldn't necessarily be a reason to.
And counsel, there was another motion made by the defense attorney after this too,
There was.
seeking judicial subpoenas. So, I mean, doesn't that sort of cut against the idea that the prior motion was open?
I don't think so, Judge, because defense counsel references again the welfare check materials that are an issue here in that January motion, that January 18th.
He's taking another tack to get at the material, because I think what the defense counsel's position here is all along, I've got to first establish this stuff exists because I'm told by the prosecutor that it doesn't exist. I really believe it does. And he's taking different taking different steps to try to get to that point, to put it back in front of the court. And his position is I couldn't put it back in front of the court until I had that FOIL response.
Well, but he knew, quote unquote, he knew that they existed, and there's no quicker way to get to a determination of that, no more practical way to get to a determination of that and solve it once and for all and dispel all doubt than to simply ask for a court to decide the motion that he brought, which he didn't do. So.
Mr. Hillary, as I read the record, Mr. Texedo says, we can just let you know if we have a problem, Judge. And the
Yes,
court says, do you want dates? No, we can just let you know if we have a problem. And then Mr. Texedo says, the next page, we need a ruling for sure on the grand jury minutes. So my point in bringing that up, it's clear as of August 14, 2023, the motion is still pending.
yes, Your Honor.
And it
Yes.
clearly hadn't been withdrawn because at a minimum, the grand jury minutes had to be dealt with.
Absolutely, Your Honor. And that's really kind of the crux of our argument here, is that the motion was never resolved. The motion remained open, remained pending. And now the question is, well, how do we reckon the time? All the time that's elapsing between the time the argument or the issue is raised and the time we get to the decision by the court. And the only reasonable way, in my estimation anyway, the only reasonable way to reckon that time is that it be chargeable to the defense. It's on his motion and it's unresolved. Unless the court has any other questions,
No other questions, counsel? Thank you.
thank you.
Counsel, proceed.
Yes, thank you, Your Honors.
You need to get close to the microphone.
Okay, I'll go.
Yeah, better.
Is that better?
Yeah.
Okay. Thank you, Your Honors, for the opportunity. On this argument that this motion was still pending and that that is the cause of the delay, we know that that's not the case because the prosecution's first argument when I brought this forward in my 30-30 motion was that Judge Hendages decided already that this is irrelevant and love, the case precludes you from arguing otherwise now. So the prosecution was acting under the assumption that this motion had already been decided.
Mr. Texano, I'm just catching up to what you just said.
Yes.
You saying that Justice Hendages found that the material in question was irrelevant?
No, I'm not saying that. What I'm saying is that that's what the prosecution thought. That caused a whole delay of 1 day in continuing the trial, responding to the motion, figuring out what was going to happen, because the prosecutor said, wait a minute, Judge Hendages already decided this was irrelevant.
And your point is would have to be that the court, Justice Hendages, made no decision on it. There had never been a ruling on it, correct?
There had not been a ruling on it, and that's because counsel had informed us that the materials didn't exist. So the ruling would have been the materials don't exist. So what we did was I took counsel at their word, and then as the trial approached and you know, clients tell you it has to be there, it has to be there, you take other avenues to try to get it. If I thought a motion was pending, I wouldn't have made a second motion 4 months before the trial. I would have simply asked that that motion be decided. And the grand jury issue that was dealt with, it was dealt with 3 days later by a written decision and just a canned informal written decision that the party's understanding was that motion practice had concluded at that point. And it was the court's understanding as well. So under the excludable time for motion practice, the delay has to be caused by a pending motion. It's not enough that there's just a motion pending. When it's not causing any delay because none of the parties nor the court believe that it's a pending motion, even if it technically is, that's not an exclusion under 30-30. The parties in the court treated that motion as withdrawn, including after I filed my 30-30 motion over a year later, because the prosecution was saying, no, this has already been decided. So for them to then say, well, the reason for all this delay was I thought a motion was pending, they knew there was no motion pending, or they did not believe there was a motion pending, nor did I, nor did the court. Nobody did.
But you didn't formally withdraw it. You clearly kept it open as of August 14th of 2023, because you were at least awaiting ruling on the grand jury minutes, right?
Yes. Well, so the court asked if we needed any other issues. My recollection of the record is that the court asked if we needed any other issues decided. I stated, no, we'll let the court know if we do, but one thing we really need decided is the grand jury minutes. And those were then decided 3 days later.
Forgive me, you did not say, no, we don't need a ruling. You simply said, we can just let you know if we have a problem, Judge.
Okay.
That's what the record reflects. Let me ask you a further question. On the flip side, I'm not sure this is pertinent, but I'll ask it anyways. If the people had moved for protective order, basically, as I understand a protective order, it's discoverable, but we don't want to produce it, but whatever. If there had been no ruling on the people's motion with respect to non-production, there's a stay in the statute, correct?
Yes.
Nothing gets produced until there's a ruling of the court. Isn't that what 245.10 subdivision 1A says?
Yes, Judge.
So until you get a ruling, if you flip that around, it's still pending.
Right.
And they don't have to produce it.
In this case, what I'd say is there was no motion for a protective order. And the reason that we never got a ruling was because the prosecution told me that the item didn't exist. So, and that is on the record. I allege it a number of times in different affidavits, and the prosecution never says otherwise because it's the truth. They informed me that the materials did not exist. And when Mr. Hillary says, well, he knew it existed, I hadn't seen it. I knew it should exist because I knew my client was telling me the police were there, and I knew the workings of West Seneca and how their body cam systems operate, which is they turn on automatically as you approach, it doesn't mean that I knew it was still there because I had taken steps to try to get it, and the prosecution informed me that they took steps to try to get it and that it was not available. It didn't exist.
Counsel, are you suggesting that clients sometimes tell you things that are not truthful?
Sometimes they do. Yes, Your Honor. They do. But you know, in this case, it didn't even have to be not truthful. The materials could have existed at one point and then ceased to exist, which actually ended up being the case here. But if we would have gotten to it within that first year after the arrest, the body cam would have been available. And just, I guess, as an update for the court, the central or the Child Protective Services case against the defendant in this case has also been dismissed by that body. So just for what that's, I don't know that that's worth anything, but it's an update on the proceedings that I wanted to give the court. But in this case, the prosecution did not, I guess they didn't act in good faith. This material was at the West Seneca Police Department the whole time. They start off saying it's not relevant, which frankly, I think is a frivolous argument. And after that, they switch to it doesn't exist. And then once we find it, then it's this has already been decided during motion practice. And then that switches to this motion was still open. And then it switches to judge, you need to recuse yourself. It's every step that can possibly taken to avoid just handing over this material that was in police possession. We worked diligently. We tried every step we could. I don't think that the time is excludable, even if the motion was technically still pending, because that didn't cause any delay, because none of the parties nor the court felt that the motion was still pending. So even if this court were to find that the motion was still pending for all that time, over a year, it doesn't cause delay because none of the parties believed it was pending. So no one was acting under that assumption. Unless there are any other questions, I will rest on my brief.
No other questions, counsel. Thank you.
Thank you, Your Honors.
Case 424, People versus Thomas. Counsel, proceed.
Good morning, Your Honors. May it please the court. Danielle Wild appearing on behalf of Hannah Thomas. The facts and circumstances surrounding Ms. Thomas's waiver of appeal demonstrate at least one of two things. They show that the parties understood the lower court's youthful offender determination was excluded from the waiver of appeal, or at minimum, they failed to show that Ms. Thomas understood that the court's youthful offender determination was among the rights that she waived. Either way, this court should hold that Ms. Thomas's youthful offender claim survives her waiver of appeal, and on the merits that the interests of justice would be served by adjudicating her a youthful offender. Beginning with the waiver of appeal, as this court well knows, the validity of a waiver and the nature and scope of the rights waived by it must be determined based on the relevant facts and circumstances surrounding the waiver. The use of the term surrounding conveys that the court must consider not only what precedes the waiver, but also what follows it. And what followed Ms. Thomas's waiver in this case was a wholly separate colloquy concerning the court's youthful offender determination. And in that separate colloquy, the court explained that if I do not advocate you a youthful offender, the maximum allowed under the law, again, for a term of at least 5, but not more than 25 years. I have to advise you on if I do and if I don't, all right? If I do not grant you youthful offender, you need to understand that this conviction is considered a felony conviction on your record and you cannot withdraw your plea. So while the court advised Ms. Thomas that if it denied her youthful offender request, she could not withdraw her guilty plea, and also advised her that she could not appeal the ultimate sentence that it imposed, what the court did not advise her in that separate colloquy was that she was waiving her right to appeal the court's youthful offender determination. And that this situation where there is a wholly separate colloquy concerning youthful offender is what excludes this case from the Pecorelli decision and its progeny. As the court well knows, the court's youthful offender determination is separate from the ultimate imposition of sentence, because although that they are addressed together and youthful offender determination is made at the time of sentencing, youthful offender is governed by a distinct and separate judicial process. It's Article 720. And here the court in fact treated those as separate proceedings. So even if the court disagrees that the record is sufficient to show that all parties understood that youthful offender was excluded from the waiver, as we submit that it does, what the record still does fail to show on the flip side is that Ms. Thomas understood that the youthful offender determination was excluded.
In line with that part of your argument, I've reviewed the very thorough Center for Community Alternatives letter memorandum that was submitted that's in the record.
Yeah.
And there's some indication in there that your client had the mental functioning capacity of, I think there's reference of maybe a 9-year-old.
Yes,
And this was
absolutely.
something that was before the court below at the time of sentencing.
It was.
Did the court have an obligation to do something further in terms of understanding your client's ability to understand
I believe
based upon the information that was before the court?
it did, and I believe the court in this case demonstrated that by largely following the model colloquy, as the people pointed out in their briefs, but taking care to explain some of the rights and some of what she was waiving by pleading guilty, and then separately by waiving the appeal to a greater extent than the court might have done in other cases. And then took the separate care to have the separate colloquy regarding youthful offender determination. Given the nature of the case and certainly the facts and circumstances of the client, it's clear that the court should have done more if youthful offender was to be waived, that determination, that should have been included here.
It seemed to be saying, if I'm recalling the transcript correctly, the court seemed to be saying that it took into consideration all of the information before it, including that report, presumably. But it took that into consideration relative to the reduction of the charge, right? And so the court's saying, I considered all that, but that's why we ended up with a reduced charge and then went forward with sentencing. But if the court didn't believe portions of that report, in other words, the court didn't believe that she was functioning at an equivalent of a 9-year-old's mental capacity, the court didn't articulate that.
The court did not explicitly articulate that, no. And, as the Court of Appeals recently made clear in Bisono, the reviewing court's task is to, cannot consider each of these circumstances in a vacuum. It has to make these individual determinations on the record before it. And the record before it here clearly establishes that that youthful determination, offender determination, should not be waived by the waiver of appeal, and also demonstrates that the interests of justice would be served by adjudicating her a youthful offender here.
If the court below, though, looking through the report indicated or believed, let's say not indicated, but believed that the report was strong in some aspects, not strong in others. In other words, there's no IQ test results in the report that's given. Maybe the court didn't believe that the child was functioning at the level that was claimed in the report, the 9-year-old level, especially based upon the fact that I think she completed her high school equivalency while in jail, correct?
She did while she was at the youth center. I believe there is some indication in the record that she did at that time.
So there seems to be some contradictory information possibly that's before the court, and the court maybe took it all into consideration. Is there any way for us to know that happened?
Well, without it being, fully, articulated on the record, the court, of course, can't know for sure whether that happened. But I do still think that the record here is sufficient to indicate that the waiver of appeal did not include the youthful offender determination in this case. And as for the merits of the youthful offender determination, Miss Thomas's acquiescence to her co-defendant's offer to kill her mother in that moment was a hasty and thoughtless act. It was one with grave consequences, sure. It was a very serious offense, but it was not the act of a hardened criminal. And that's exactly what the youthful offender law is designed for, is those hasty and thoughtless acts of youths that are not the product of a hardened criminal.
Isn't the opposite reading fair here also, that her reaction to that offer was calm and an acquiescence, and her reaction to what she found downstairs, there's no indication that there was anything that was other than somebody that was a stone cold killer.
But Judge, respectfully, that's looking at the emotional reaction of a fully developed neurotypical individual, which Ms. Thomas is not. The record is very, thorough here in explaining that Ms. Thomas did not convey her emotions in the way that others may typically expect to see them. And instead, what it does show, though, is that she, did ultimately take responsibility here by both giving, a statement to the police after her arrest and also by ultimately pleading guilty. There is also some indication elsewhere in the record that she was remorseful for what happened. She had just been, starting to get reunited with her biological family, her grandmother, who was a strong advocate for youthful offender and was the mother of the victim in this case, spoke to the court and indicated that, that she believed that Ms. Thomas was manipulated by her co-defendant. And in that moment, especially based on the other triggers of what happened earlier in that day, did not actually mean or want for her mother to be killed. This case, is, certainly, a bit different from Cruikshank, if I'm pronouncing that correctly. But that case is informative here. Where in that case, it was a 17-year-old defendant, who shot their father in the back of the head 9 times. And the court in that case indicated that was that was not the cold and calculating product of a criminal mind, but the result of emotional trauma brought about by no fault of her own. And in this case, there were some early triggers, re-triggers of her trauma in that day. It's shown in the record, Ms. Thomas has a life that was just very much marked by being out of control and having no autonomy over her own life and choices and feeling powerless.
Here's my concern, counsel. The report is, as I said, thorough and it's compelling. But is the court below required to accept the truth and veracity of, there's a lot of scientific studies referenced, there's scientific determinations referenced, there's findings of fact within that report. Is the court below obligated to just accept all of that, or are you suggesting the court below was required at a minimum to run a hearing if the court had any qualms about it, or if there was an objection to it?
Well, there was no objection to it, and the court certainly didn't indicate that it disagreed with anything that it said, and seemed to have credited the report. And this court has credited the Center for Community Alternatives reports in the past as well. And even if we look, don't just focus on the CCA memorandum, but look elsewhere in the record, her abuse and her trauma is well documented and certainly not in dispute of what happened here. We also have
It's not the abuse necessarily, it's her, how did the abuse affect her? That's what's important for us and for the court below to understand, right, at the time of sentencing.
Well,
how did that impact her?
In the PSI, the arresting officer statement isn't actually included in this PSI, and the arresting officer recognized in that short time that he spent with her that she likely was manipulated by her co-defendant. And he believed that she was manipulated by her co-defendant. And even, without, given her her atypical emotional responses, and he did also indicate that she was cooperative.
But you're not arguing that we should, as a court, assume that the statements made by police officers in their opinion of defendants is what should control.
I'm not suggesting that's what should control, but what I'm suggesting is that there's certainly other indications, particularly soon after the offense, where, that is exemplary and does go to show what her state of mind was and how the trauma and her response to her trauma affected her decisions in this case. And so having that, clearly, an objective opinion by the officer believing that she was manipulated, that at least supports and lends credibility to the rest of it. We have the grandmother here, the grandmother who, her statements as well, indicating, what Miss Thomas was like and how she responded to situations.
The mother of the victim,
Yes,
is supportive of the defendant in this case.
that's correct. Yeah. And so all of that, together with the CCA memorandum, shows how much that, her trauma impacted her decisions in this case. There's no other questions.
No other questions, counsel? Thank you.
Thank you.
May I please the court? Christina Harper for the people.
Are we foreclosed from exercising our interest of justice authority in this case?
Your Honor, by virtue of her waiving, by the defendant waiving her right to appeal, and as argued in my brief, the waiver was knowing, intelligent, and voluntary, yes, based on a Court of Appeals decision.
So
In fact,
let me drill down on that just a little bit. So the agreement to plea this case and to sign the waiver of appeal that was negotiated between the prosecution and the defense below, not before this court, removed from this court our authority to exercise our interest of justice. And so what you'd be saying is that the defense attorney and the prosecutor below can remove our authority on their own. Is that what's happening here?
Your Honor, this court in People versus Birch this year confirmed that the valid waiver of appeal precludes appellate review of defendant's challenge to the court's consideration of the denial.
If that's true, is there a distinction between the defendant being able to raise to us interest of justice? Hold on, let me finish. In other words, because of the waiver, the defendant's foreclosed from raising that issue before us. Is that the same as us being foreclosed from exercising our own interest of justice on our own?
Your Honor, I believe that she did knowingly waive her right to appeal, and that's what's
What
controlling.
if I concede that? What if I concede she knowingly waived her right and therefore she can't raise her interest of justice, and therefore on appeal, when that's raised before us, you're proper in saying defendant's foreclosed from raising that? Is that the same as saying we're foreclosed from addressing and exercising that interest in cases where we think it's important to be addressed?
Your Honor, I still, certainly this court does have an interest of justice jurisdiction. However, I believe the law is very clear here. First and foremost, this court has to review whether or not the waiver of the right to appeal was valid. And because in this case it was valid, this court should not review the claim of that defendant makes here on appeal.
So the response is I understand it, and I understand. I think that's probably the appropriate response. That because the defendant waived it, the defendant's foreclosed from raising it, and this court should not exercise the interest of justice authority that we have because the defendant waived it. That's a little different than saying that we're foreclosed from raising it. We should not versus we can't.
You and I would argue you should not, and that's what is based on the decisions on the court precedent, and especially the most recent cases that were decided by this court, and I would cite People versus Birch in that respect. In reviewing this record, it becomes very clear that the court advised the defendant of the rights that she was waiving, including her waiver of the right to appeal. Like in model colloquy, the court explained to the defendant that she did not give up her right to take an appeal, and that's what that's what the defendant is doing here. She's taking an appeal. However, most of the claims of error are precluded by her valid waiver of appeal, Your Honor. And this is why I believe this court should not be reviewing this claim because of this valid waiver. The Court of Appeals decided that this is one of the rights that is waived by a valid waiver of appeal. And this is why this court is precluded. And in getting into the substance of the defendant's appeal, when it comes to youthful offender adjudication, I would note that the court does not have to state the reasons for denial of the youthful offender adjudication. Yet here, the court did state the reason. The judge did say, I'm not unsympathetic to the trauma that Ms. Thomas faced in her very young life, but that trauma does not obviate the severity of the facts of her decision that she made that led her into this court. Therefore, based on the gravity of the circumstances of this case, I do find that the interest of justice would not be served by adjudicating you as a youthful offender. This was a very well-reasoned decision. There was litigation that preceded the plea and the sentencing. The court was presiding over suppression motions, suppression hearings. As stated on the record, the court did have multiple.
Counselor, I'm sorry if even if the court, if we did have some inherent jurisdiction here in the interest of justice, even if the court did not abuse its discretion, which I mean, we could still exercise interest of justice jurisdiction if it wasn't otherwise precluded.
If this court were to exercise the interest of justice jurisdiction.
The court could have been right in making a determination and not having abused its discretion, but nevertheless, in the interest of justice, we could see it differently.
Yes, but I would argue that the lower court's determination was correct. I would point out to the severity of the charge. The defendant was.
That's an argument that addressed to the interest of justice argument here that you're making. That the court below is correct in its determination vis-a-vis interest of justice.
And should this court exercise the interest of justice jurisdiction, the decision should be upheld of denial of the youthful offender adjudication, given the severity of the facts. And again,
But I think Justice Whelan's question was, do we still have to do that analysis here?
Your Honor, I don't believe this court gets this far because of the valid waiver of appeal.
Your position is we can't even begin the analysis. That even if objectively it was against the interest of justice at the outset, we couldn't exercise that jurisdiction.
Yeah, and I don't believe this was against the interest of justice. First of all, this court obviously has to look at the waiver of appeal. The waiver of appeal precludes even review of the denial of the youthful offender adjudication. So that's my argument. So because of this valid waiver, this court is precluded from reviewing the youthful offender adjudication. Even if this court were to review it, the youthful offender denial in the interest of justice, I would argue that the gravity of the crime and the manner in which it was committed speaks for denial of the youthful offender adjudication here. It was very telling that it took 3 hours of police interview for the defendant to finally admit that her mother was dead. I would point out to the fact that both defendants tried to make this entire incident look like a burglary gone bad by ransacking the upstairs bedroom, not touching the downstairs salon that was equipped with surveillance camera. Then the defendant admits that she goes into the kitchen, probably stepping over her dead mother's body, retrieving the keys to her car. Then both defendants drive 900 miles away from the scene of the homicide. They're speeding. They are finally stopped in Missouri.
We're familiar with the record, and your argument is all of these acts lead to somebody that should lead to a determination that this was a calculated murder, and that she understood it, she consented to it, and she participated, especially in light of the fact that she flees with the co-defendant and they try and escape the jurisdiction of the court.
Yes, Your Honor, and there was absolutely no remorse.
I think we understand that.
Thank
Ms.
you.
Harper, before you leave, you're saying that because the plea waiver was valid, the defendant, it was explained to the defendant, counsel was present, defendant said they understood, that we never even get to the second prong of that argument.
Yes, Your Honor. I believe that the waiver was absolutely valid, and that's what precludes the review of the question that defendant is raising on appeal.
Thank you.
Unless there are any other questions, I will rest on that.
No other questions? Thank you,
Thank
counsel. Case 425, People versus Rosa. Counsel, can you hear us?
I can. Can you hear me, Judge?
We can, but I'd ask you to just keep your voice up, please, and please proceed.
Thank you. Good morning, Your Honors, and may it please the court, Peter Banishak for Eli Rosa. I'd like to address the first 2 points in our brief this morning, starting with point 1, which is that the lower court here erred in denying the defense request to charge the affirmative defense to felony murder. The court applied the wrong legal standard and also appeared to fail to view the evidence in the light most favorable to Mr. Rosa. When the correct standard is applied, there is a reasonable view of the evidence in this record to support each one of the 4 elements of the affirmative defense. Starting with the first 2 elements, there's a reasonable view that Mr. Rosa did not commit or in any way aid the homicidal act or possess a deadly weapon. And I think it's notable.
Mr. Banaszak, let me stop you right there, because that's sort of what I'm focused on at the moment. Looking at that very first sentence of the affirmative defense, it says, did not commit the homicidal act or in any way solicit, request, command, importune, cause, or aid the commission thereof. Would you agree that there's nothing in that statute that says that the defendant has to cause the homicidal act?
That's true. It has to be either, well, right. The defendant could neither have caused nor in any way been an accessory to the homicidal act.
So the statute doesn't require that the defendant cause the homicidal act. But your argument is, I understood just now, and you also said in your brief, that you needed to show that the defendant did not aid the homicidal act. But that's what you just said. The way I read the statute, it says he must show you did not aid the commission thereof. Is there a difference between aiding the homicidal act and aiding the commission thereof?
I don't think so. I think the distinction that I was making in the brief is that aiding the underlying crime is not the same thing as aiding the actual homicidal act, or aiding the commission, or being an accessory, or whatever the language you want to use. And I think that's the key thing, that in every case where this affirmative defense applies, the defendant is going to be in some way, shape, or form involved in the underlying crime. Otherwise, there would be no need for the affirmative defense. And I think here I would make 2 points at least. Number one is that the jury's own verdict supports the fact that Mr. Rosa was not involved in the homicidal act or in possession of the weapons, in that it acquitted him of the weapon possession offenses, as well as the intentional murder, as well as the lesser included manslaughter count. So the jury itself did not believe that he in any way aided the commission of the homicidal act itself. The prosecution's brief argues that he aided the commission of the homicidal act by driving the co-defendants to the scene and robbing the driver of the vehicle, not the actual homicide victim. Those things, I think, at best show that he aided the underlying crime, but not the homicidal act itself. And I think a useful comparison is the people's reliance on People v. Gordine, where the defendant actually restrained the homicide victim himself after one of the co-defendants brandished a weapon. That is simply not the case here. Mr. Rosa did not touch the actual homicide victim or play a role in the specific homicidal act. He may have committed a robbery of the driver, but he did not actually play a role in what happened to the decedent.
Counsel, is it important that the defendant, through the interview, right? He didn't take the stand here, but there was an interview that I think was played to the jury. Do I have that right?
Yes, Judge.
Yeah. During that interview, he claimed to not know that there was guns involved.
That is important, Judge, and we rely on that, on his interview quite heavily, because it demonstrates, I think, the affirmative defense as a whole, and certainly the third and fourth elements, which is that the defendant had no reasonable ground to believe that the co-defendants were armed or were likely to cause death or serious physical injury. Mr. Rosa specifically said that he did not know that his co-defendants had weapons and that he did not know what they were planning. He explained that he was on the phone in his car. He was doing his own thing. He was not aware of what the co-defendants were doing. And viewed in the light most favorable to Mr. Rosa, those statements supported the affirmative defense. Again, cases that the prosecution relies on are a good comparison. In People v. Cicado, the statement that the defendant gave to police did not indicate that he had no knowledge of his co-defendant's possession of a weapon. In this case, Mr. Rosa explicitly stated that he did not have that knowledge either of the weapons or what their plan was here. People v. Merchant, the defendant's statement revealed that he knew his co-defendant had a baseball bat and intended to use it if the robbery in that case went awry. In this case, we have no similar admission. We have a circumstance where the defendant's statement, viewed in the light most favorable to him, supports the third and fourth elements at minimum, but I think also the affirmative defense as a whole, as does the surveillance video itself that captured this incident. It depicts that the two co-defendants are the ones who actually are involved in this struggle with the passenger, and it shows Mr. Rosa heading to the other side of the vehicle when the gunshots go off. If we view the evidence in the light most favorable to Mr. Rosa, we can't even know whether he knew that it's his co-defendants who fired a gun or whether it was the passenger. He ran over to the driver, he pushed her down, he took her purse, he admitted to that. Again, though, that's participation in a robbery. It's not participation.
Mr. Vanderzeck, one further question for me on that fact, and I don't recall, but does the evidence reflect that the defendant did those acts that you just described, pushed the driver over and stole the purse after the shot was fired?
I think that that is a possible interpretation of the record, that he is somewhere behind the car when the shots go off. He appears to maybe be startled when that happens. He then runs over to the driver and takes the purse.
So he advanced to the area where the crime was committed even after he heard the shot.
Well, I suppose the jury could have viewed it as advancing away, in that he's on the other side of the car. I think, Your Honor's interpretation may be possible, but I think we have to remember that the standard is the evidence viewed in the light most favorable to Mr. Rosa. So we have to accept his version, essentially, that he did not know what was going on. He ran up to the driver, he took her purse, and then he ran away. And that view of the evidence does not establish that he in any way furthered, solicited, advanced, aided, or anything else the commission of the homicidal act itself, and which again is separate and distinct from the underlying robbery charges. Finally, on this point, with respect to the remedy, at minimum, obviously, the court would have to grant a new trial on the felony murder count. I think a new trial would also be warranted on the other counts, because had the affirmative defense charge been given, it is possible that the jury's focus would have been drawn to Mr. Rosa's specific actions, his specific involvement in this incident, and they may have potentially acquitted him of one or more of the robbery counts. If this court only reverses the felony murder count, then at minimum, it should vacate the sentences on the 2 robbery counts, because it's very likely that the court's sentence on those counts was influenced by Mr. Rosa's conviction of the felony murder. Moving on to point 2.
Be mindful of your time, counsel.
I will, Judge. Thank you. And essentially, the gist of our argument is that the lower court did not obtain unequivocal assurances from juror 18 that she could be fair, after she stated that maybe the defendants were here for a reason, suggesting that she would take an inference of guilt by virtue of the fact that they were on trial. I think the key thing, as far as our argument is concerned here, is that this court should compare the court's colloquy with juror 12 versus the court's colloquy with juror 18. And with respect to juror 12, on page 509 of the trial transcript, the court asked that juror a key question. She stated that the fact that the defendants are here, you cannot hold that against them. Juror 12 indicated that he understood that fact, and said he could be fair and impartial, and said he could follow the presumption of innocence instruction. That specific question was not asked of juror 18. I think respondent's brief suggests that it was, but our position is that on page 508, the court addressed the presumption of innocence instruction to the entire panel, but the key question about not holding against the defendants that they were on trial was only asked to juror 18, and that was the key question that was necessary here in order for juror 18 to clearly express that the belief she previously stated on the record would not impact her ability to be fair and impartial in this case. Thank
Counsel, you should wrap up.
Thank you, Judge. That's all I have.
Thank you.
Good morning, Your Honors. Ryan Ash for the people. Regarding point number 1, it's the people's position that the court did not err in denying defendant's request for an instruction on the affirmative defense felony murder because, at the very least, people established that in any reading of the evidence, defendant aided in the commission of crime. Yes,
Counselor, the defendant's interview, I mean, if it was to take that in the light most favorable to the defendant,
right.
If you were to believe that maybe the jury would or the jury wouldn't,
Right.
But to light him most favorable, how do you then avoid the fact that defense says, I didn't know what was going on, I didn't participate, I didn't know there were any guns in the car?
Your Honor, I think that without weighing the evidence, with just looking at the evidence in support of defendants'
Right.
arguments for this affirmative defense, I do not think that any part of defendant's statements undermined the fact that he continued to participate after a shot was fired. And that was also
Right,
the
but
only,
that's, you're inferring from other events, other circumstances, right? That causes you to take that leap. But if you were to otherwise view the evidence in the light as we must,
Right.
as favorable to the defendant, and you don't take that leap, you don't draw that inference against the defendant.
so I guess my argument would be taking the evidence in the light most favorable to defendant doesn't require ignoring the evidence that goes against his arguments if it's the only evidence that's presented. His statements in his interview, my recollection is that they are mainly, if not entirely, focused on the events leading up, how much he knew about the plans of his co-defendants. But his statements don't go to the actual acts that occur. The only thing he says, I think, about the reason for actually assaulting the surviving victim was that he thought she was someone who was going, like another man perhaps, who was going to try to intervene to stop the
But that was
robbery.
after the guns fired.
Right.
How did that, even if that's the case, how did that assist in the murder? If it happened after the shots were fired?
Well, the murders aren't necessarily, and this one certainly wasn't just like an on-off switch. The commission is a series of events, and I believe my recollection too is that there was more than one shot fired. I believe
Yeah.
there was 2 shots fired.
Right.
So the act itself, although it's presented in the statute as a singular act, we really are concerned with the course of conduct here. And the course of conduct was a struggle. And defendant's role in the struggle, and I believe it's quite evident if you look at security footage, the defendant's role in the struggle was to go on the passenger side and take care of whoever was on that side. And in this circumstance, it happened to be a woman who was not armed. And he participated in the commission of the offense, and he actually aided the commission of the homicidal act by being the person over there who was pretty clearly, and from my watching of the tape, was the person, his role was to take care of that side. His role was to say, if there's someone over there, and I think they knew that on the text messages, I think he established that he knew there was going to be another person there. And that's why he was required.
Counsel, let me ask a question. If the jury were to have given the charge that they wanted here on the affirmative defense, and the jury were to conclude and find facts that, one, they agreed that the defendant didn't know guns were involved,
Okay.
thought they were driving to, I think they referred to it as a let out or something, but to a party, and then realized that there was going to be a robbery, and he went with his pals to the robbery. If they agreed with those facts, and that the defendant was going around the back of the car over to where the other person was to commit a robbery, would you then agree that he was not part of the commission of the homicidal act?
So specific to prong A of the affirmative defense, I still don't think so. I think intent is not something in this circumstance that is formed at the outset and they plan on what their intent is and they go out. The intent, just like the act itself, is an evolving thing as the crime goes on.
Well, when the crime happens, he's around, having watched the video, he's around the back of the car. He's not
with the person
who's committing the crime, who's actually committing the homicidal act,
Yeah, okay.
right? He's not with them.
He's not on that side of the car, but
Right.
he's certainly part of the 3 of them because it required 3 people.
But my question is this, that if he's where he is at the time that the homicide occurs, the trigger's pulled,
Okay.
okay? If he's on the other side of the car looking to go commit a robbery, and that's what he thought was going to happen,
Yes.
and the jury believes that,
Okay.
would you then agree that they did not intend to assist in the commission of the homicidal act?
Your Honor, I don't believe so. If we're talking about after the first shot goes off, I believe after that point, he still is involved in committing the acts.
Let me stop you there, though.
Yeah.
You're
talking about that you're
just as the gun went,
As the pull of the trigger.
at that point, forget about what happens afterwards.
Yeah.
Was he and did he assist in the commission of a homicidal act?
Yeah, I would still say yes, Your Honor, because I don't interpret the act.
Then I got your answer. Let me
Yeah.
add this question.
Okay.
Do you think that's a jury determination? Because they have to find facts, and it shouldn't be necessarily a judge's determination. It should be a jury determination on the finding of these facts.
Your Honor, no, I don't personally believe, because again, that's only going to A. And my point is that I don't believe as a matter of law that he established, viewing the light most favorable to him, that he didn't aid the commission of. Because a couple of reasons. Number one, it's undisputed that it was his car and he drove in there. I'm also arguing that's aiding the commission of the act, because
So if he's driving the car with the idea that they're going to a let out,
to a party.
to a party,
Okay.
yeah, whatever the phrase
Yeah.
is, yeah, to a party. And they get to that place. Even before they get out of the car, before he sees that there's a robbery, before that point, he's assisting in the commission of a homicidal act at that point?
Well, no, Your Honor, unless in this circumstance, as it does, a homicidal act occurs. The homicidal act happens afterwards.
But the driving part,
Yes.
if the jury believes he had no idea, and they get out of the car,
I see what you mean.
the
Okay.
driving part didn't assist in anything at that point, because he didn't even know anything was happening.
Except for the fact that driving, let's not just consider as a event prior to the act. He was with them, I believe he was with them as they left the scene. So being the driver is just as much a part of committing the homicidal act as another role.
No,
If he knows,
the cases tell us that if he knows there's a gun, if he knows they're going to commit this crime, he's part of it. He's driving them there with that understanding. I understand your argument.
we're assuming.
I'm saying that if the facts the jury finds are, he's driving them to a party, and
Okay,
he doesn't know there's a gun in the car, and they get out of the car. How was driving them to a party, the driving an intent to commit a homicidal act? You see my?
yes, I understand. I think that I am interpreting the act differently than you are in that hypothetical.
What's the homicidal act?
The robbery, the
The
fact that,
robbery is the homicidal act?
yes, because it's what the shooting of the person during the robbery.
Isn't the pulling the trigger the homicidal?
Well, it's the physical movement, but we can't look at that in the vacuum. Otherwise, there would never be a situation where someone who's not a trigger man is convicted of felony murder. In this circumstance, and I believe, and we are getting a little bit down on A, and I want to also focus on the other subdivisions. I think the only subdivision that really is not at issue here is subdivision B, but I'm also arguing that the people met their burden to establish that it wasn't required because evidence of this subsection C and subsection D. And even if everything else, at the very minimum, he participated in a robbery, a violent robbery. And even if that intention forms after he gets out of the car, he knows he's participating in a violent robbery because a shot goes off. He knows that he's trying to restrain this person and rob them and stop them from intervening. That meets, I believe it's subsection D that talks about things that could result in serious physical injury. And so I don't believe that subsection A is met either, but I certainly don't believe that C and D are met here.
I think we understand your argument.
Thank you. Would you like to hear questions on my other point?
Yes, I mean, if you,
All
I
right.
don't want to
I should have said, do you have any questions on point 2?
no questions.
Thank you. Your
Thank
Honor.
you. Case 426, People versus Nelson. Counsel, proceed.
May it please the court, Krista Markarian for Cameron Nelson. Mr. Nelson in this case was not driving recklessly and he was not the cause of the accident. It was the third car involved in this case, the Infiniti, They were speeding, ignoring traffic signals. They drove in the oncoming lane. And ultimately, they also hit the back of Mr. Nelson's vehicle, forcing him into the oncoming lane of traffic. As noted in the Court of Appeals case of People v. Cabrera, speeding in itself is not enough to sustain a finding of recklessness. Here, Mr. Nelson was taking care. In this case, he was abiding by traffic signals. He was wearing his seatbelt.
Speeding by itself is enough, but is going 80 miles an hour in a 30 miles an hour zone in a race, is that enough? That's another element to this, right? That's another factor.
Right, Your Honor. First, I would note that there was not enough evidence in this case to establish that there was a race. Well, there's
a witness that said the cars were racing, right?
The witness in this case just knows that the cars were driving side by side. I would also note at the outset of this case, there was a statement made by the district attorney that racing could not likely be dispositively proven. And also in two statements given by Mr. Nelson, he heavily stated that he was not racing. There, I would note that in this record, there was not enough to prove the additional affirmative act was racing. Therefore, given only the speed itself, there needs to be something else to show the recklessness in this case. I would note that Mr. Nelson was dealing with an unforeseeable chain of events. He's at a light with his Infiniti, it takes off. As he continues on his way, all of a sudden there's a green light, but the Infiniti is back, but they're braking. He takes it as he's trying to continue on his way. That's when he decides, I don't know what this car is doing. He passes the car, takes care not to hit a car that's in the right-hand lane. The road that they're on is commonly used as a road for two cars. I would note that there was not an additional affirmative act in this case besides speeding, especially given the Infiniti's unforeseeable behavior. As to point two of my brief, I would note that Mr. Nelson driving without a license was improperly used as direct evidence of recklessness. In this case, this was not necessary background material. This was a separate and distinct act. As held in civil cases and general negligence, not having a license merely goes towards your authority to drive, not the manner of operation. And here, the trial court improperly relied upon this evidence. They used it as their first basis of finding recklessness in their verdict. They also heavily relied upon it during sentencing. This was an improper use of this evidence. There was no balancing test provided. And as the Court of Appeals provided in People v. Caban, where a license suspension in that case was directly related to the cause of action, there was no similar prior history with Mr. Nelson in this case. Therefore, the trial court's allowance of this evidence, it was used in the prosecution summation, heavily relied upon the trial court that it was improperly used as direct evidence. And I would also further note as to point three that Mr. Nelson's sentence was harsh and excessive. He has no prior criminal record. He was remorseful. He was never offered a plea offer. He was compelled to go to trial. He was cooperative with law enforcement throughout the case, and given other factors such as his steady employment, family ties in his childhood, and that he was given most notably the maximum sentence, his sentence should be reduced.
Thank you, Counsel.
Thank you.
May it please the court, Jerry Marti for the people. This is more than a speeding case. The facts show that the defendant went from 0 to over 80 miles per hour, never stopped, never slowed down, kept accelerating, and had a cognitive impairment due to marijuana. This is corroborated by witness testimony, by videos, and from crime scene investigation. Now, one of the things that was brought out in the brief is that the defendant says another vehicle was involved and caused his vehicle to veer into oncoming traffic. However, the officer testified that there was no debris on the road and there were fairly linear tire marks, which suggests that the defendant lost control of his vehicle and it had nothing to do with another vehicle. In the light most favorable to the people, there was legally sufficient evidence. As to the Molyneux, the court did not abuse its discretion. It's a two-step process. The first is whether there's an exception, and here there is. It provides background information and narrative events. It shows the successive steps that the defendant took in consciously disregarding risk, and therefore its probative value outweighed its prejudicial effect. Even if it didn't, it was harmless error. There is no reasonable probability of an acquittal without that alleged error. Lastly, as to sentencing, the defendant points out that he's young and he didn't have a criminal background. I would point out that there was an outpouring of victim impact statements in this case. The victim was 24 years old and she was obeying the law, the rules of the road that night. And therefore, that is not a compelling reason to change the sentence. And unless there's any other questions, I'll rest on my beam.
Thank you, counsel.
Thank you.
Case 428, People versus Brown.
Good morning.
Morning, Ms. Keem. Counsel Helmbeck,
Good morning.
we can hear you. Can you hear us?
Yes, I can.
Mr. Keem, same thing?
Yes, Your Honor.
Very good. Please proceed, counsel.
May it please the court, Brad Keem for Elton Brown. I'd like to start my argument with law enforcement failing to adhere to Elton's invocation of his right to silence. After Elton was arrested for the possession of cocaine, he's speaking to police officers, he's negotiating with them. But when the conversation shifts to Brittany Yurden, Elton said, "I'm ready to go. You ready to take me downtown? I don't want to talk anymore." We would assert that that is a clear invocation of his right to silence, and that at that point, the interrogation should have stopped.
Counselor, we've seen the interview, but do you disagree with the court below that he may have said that, and she acknowledged that, but he didn't stop talking. He just continued to try to negotiate some kind of favorable term on the drug charge or prospective drug charge.
Yes, Your Honor, he absolutely was a talkative individual. But at the same time, when he says, "I don't want to talk anymore," scrupulously safeguarding his rights, I think it demanded that the officers take a moment and stop speaking to him. And
Counsel, have we ever, I mean, it's interesting, you know, if a defendant says, "I'm done talking, you know, I want a lawyer," do the police have an affirmative obligation at that point if, without any questioning, the defendant starts talking again and asking them questions and making statements? Do the police have an affirmative obligation to now tell him to stop talking? And have we ever said that?
no, I wouldn't say that the police have an obligation to tell him to stop talking, but they would have an obligation to stop asking questions. And that, I think, is the difference.
But don't we have cases where, very similar to this, where the defendant evokes his right to remain silent, but then on his own voluntarily talks and is asking questions and is making statements? And I don't know that we've ever said at that point that the police, he's no longer re-engaging, I guess is how I'd best say it. The defendant re-engages after saying that I want to exercise my right. And that's what seems to happen here. And I don't know that we've ever had a case, or at least I don't remember any case where we've said, no, he can't re-engage. He doesn't have the right to withdraw his right to remain silent. He can continue to talk and negotiate, try and get a better deal.
Yeah, I do think it's unique. It's much different factually than Zacher, Flowers, and Ribel, the cases relied on by the people. I didn't find those to be overly persuasive. And I do think it's interesting that the police continued to ask the questions, and that is what I would encourage the court to take a strong look at, is that the court or the law enforcement continued to ask these questions. If he invokes his right to silence and then continues to speak, that's one thing. But I think the police continuing to engage him is another. If I could talk, please, unless the court has further questions, I would like to talk about the sentence. So there's just such a huge disparity in the sentences between Elton, Brittany, and Norman. Brittany, 23 to life, Norman, 38 to life. Elton received 50 years to life, and the people have no idea who the individual was that shot at one individual or killed another individual. We acknowledge that Elton has a criminal history, but it is of drugs. It is not of violence. And he's 40 years old, and we'd ask the court to give him a sentence more commensurate with the other co-defendants, and that allows him to demonstrate his rehabilitation, before he is, 90 something.
Okay. Anything else, Counsel?
Yes, we raised several other issues I'd be happy to talk about if the court has any questions.
No questions, Counsel. Thank you. Counsel, proceed.
Thank you. On the first issue that was raised on the suppression issue, obviously our position is, as the court has indicated, that it was not an unequivocal assertion of his right to remain silent. The words may appear unequivocal. I don't want to talk anymore. But the context is, as the court has already viewed, of that those words were spoken in, as you can clearly see on the videotape of his statement, is that, as the lower court said, he just never stopped talking. And it was, as argued in the lower court by the people, it was sort of a negotiating tactic. I don't get what I want. I'm not going to talk anymore. But then I'm just going to keep talking, and which is what he did. And
but Counsel, can you address your opponent's argument? He says that that's fine. He can keep talking. What the officers, the investigators can't do is ask any more questions.
I would disagree with that, Your Honor, because I think that's the point of the unequivocal. What makes it equivocal is that though he said the words, he kept talking. And once his equivocal assertion is not enough to trigger their requirement that they stop interviewing him. And that's what makes it equivocal, is that he just keeps talking. It's just words. It has no meaning in that context. In regard to the sentence, it obviously within the sound discretion of the court, he had a fairly extensive criminal history, and the circumstances of this case warrant a very serious sentence. Obviously, the court thought the maximum sentence, because of his criminal history, was appropriate here. We would leave that obviously to your discretion whether to uphold that. But we would ask that you do, because the court heard this case, heard the testimony, heard from the witnesses, and based its decision on all of that. So,
any further, Counsel?
Nothing further unless there are other questions.
No questions. Thank you, Counsel.
Thank you.
Case 431 in the matter of Kristen Davis. Counsel, can you hear us?
I can, Your Honors. Can you hear me?
We can. Just stay close to the microphone during your argument is all I'd ask. Okay, very
Sounds
good.
good.
Please proceed, Counsel. Thank you.
Thank you. Good morning, Your Honors. In two recent cases, this court has reinstated arbitrator awards under Article 75 involving virtually identical circumstances. Those cases were Spence versus Sunni, decided last fall, and Cooper versus Roswell Park, decided approximately 2 weeks ago. We would ask this court to treat those cases as controlling and reach the same result, primarily because they all involve a common set of facts in that those facts are undisputed. The employer here, OMH, required Davis to receive a COVID-19 vaccine. It advised Davis, as well as all other employees, that her continued ability to remain on the job depended on it. Davis was aware, and she refused. And under those same kinds of facts, this court has upheld the termination of employees, or awards upholding those terminations, as rational. Now, Davis tries to distinguish Spence and Cooper on the ground that her case involved a request for a medical accommodation prior to the discipline. She convinced Supreme Court that this was a meaningful distinction. Supreme Court rested much of its reasoning on its disagreement with the accommodation request. The problem with that is that review is limited to the arbitrator's award. And if we look at the arbitrator's award, the arbitrator had that same argument that there was an impropriety with the denial of the request. And the arbitrator said, this is not within my jurisdiction under the collective bargaining agreement. And what that means is that the issue in front of Supreme Court never was the merits of the accommodation denial, but merely whether it was rational for the arbitrator to decline to exercise jurisdiction. The answer to that question is yes, for several reasons. First off, the CBA is wholly silent on that. You could go through the CBA that's in the record. It doesn't mention accommodations at all. A related reason is because the arbitrator's jurisdiction arises under Article 33. Article 33 is all about discipline. There's nothing about reasonable accommodations that is inherently disciplinary, as the arbitrator notes. Third, there are multiple other arbitrators who have reviewed the exact same issue, and they too have found that denials of accommodation requests are not disciplinary. They're not arbitrable under that CBA. And one of the reasons for this is that there is another forum in which to litigate these issues, namely an Article 78 proceeding. That's something that Davis could have pursued. Instead, she persisted in her refusal, found herself in the disciplinary process, and pursued arbitration. Davis's primary response to this is that even if what I'm saying is true, the notice of discipline itself required the arbitrator to look at the accommodation denial because it references the lack of an accommodation right in the charges. But that actually makes sense for the notice of discipline to use that language, because if we look at Part 557, that's a set of rules that OMH is enforcing here. They require that all of these hospital employees either receive a COVID-19 vaccine or they receive an accommodation that excuses them from being subject to the vaccine requirement. And you're only going to get disciplined if you've received neither. So we charge that Davis received neither. The arbitrator took those charges at face value. It's alleging as a factual matter. You didn't receive a vaccine. You didn't receive a reasonable accommodation. I suppose that's something that could have been contested factually. For instance, if there had been an accommodation request pending, or even if there had been an ongoing Article 78, she could have said, it's not true that I lacked a reasonable accommodation, at least not yet. But Davis wanted the arbitrator to understand the charges vis-a-vis the CBA in a way that was a little bit more convoluted to allow the arbitrator.
Mr. Hitchens, real quick. This is sort of how I have it in my head, and I want you to let me know if that's incorrect. But vis-a-vis the substance of the determination of a reasonable accommodation, that matter is for Article 78 because it's an entirely separate process that could be both a reasonable accommodation for an excuse to COVID or some other reasonable accommodation. There's a whole separate path. So the substance of that determination is one thing. The existence of a defense, if it existed, would be in the discipline. Since there was no defense that existed, that was the end of it for the arbitrator.
That's correct, Your Honor.
I'm messing this up. I want you to let me know, or if you disagree, please let me know.
Well, I could elaborate on what you were saying, Your Honor, about how accommodations really aren't disciplinary. Imagine, for instance, a common accommodation these days is a standing desk if your back aches. If you're denied that accommodation, it doesn't mean that you've been disciplined. If you have to continue sitting at your desk, it doesn't mean you're going to face discipline. It's apples and oranges. And if you're denied an accommodation, whether it's that standing desk or whether it is the ability to continue working and not receive a vaccine, you pursue a different path. And so there is no defense in the arbitration to the effect that, yes, I do not have an accommodation, but you should deem me to be excused nonetheless because the denial of the accommodation is not fair. That is an OMH determination. That is reviewable in the courts. Maybe it's reviewable by the Division of Human Rights. It's not reviewable in the context of a disciplinary arbitration. And unfortunately, Supreme Court doesn't conduct this analysis at all. Supreme Court simply looks at the denial of the accommodation. The court decides that it disagrees with OMH's determination, not the arbitrator's jurisdictional ruling, OMH's determination, and says that as a result of that of my disagreement, the court's disagreement, I'm going to vacate the discipline determination and reinstate her to employment.
And counsel, you're saying that the court's jurisdiction in this case is very narrow. And the court should never have entered into that analysis.
The court never should have looked past the arbitrator's ruling that it lacked jurisdiction and gone to the merits of the denial. And
I think we have that argument, counsel.
Thank you, Your Honor. There is one other alternative that I will address briefly, which is the interest of justice or public policy reasoning. Davis and the court seem to be relying on the medical professional's decision. That was the decision that declared that a DOH regulation was invalid. This court in Spence held that medical professionals wasn't enough to establish contrary public policy in a case where that played a prominent role in the discipline. There's no way that it could establish public policy here where that regulation didn't factor in at all. This is an OMH regulation promulgated under the mental hygiene law, and that law unambiguously enables OMH to set policies and procedures at its own hospitals. That's 7.17a. What that means is that Supreme Court could not have made a ruling on the validity of 7.17 or Part 557 without doing so for the first time, because no court has ever held that there is no ability to direct OMH's own employees to receive that. And to do that, that means that once again, the court is going beyond Article 75's extremely limited review power and conducting extended legal analysis. So whether it's looked at through the lens of rationality, public policy, or interest of justice, Supreme Court transgressed Article 75. For that reason, we would ask that this court reverse Supreme Court's order and reinstate the arbitrator's award.
Thank you, counsel.
Thank you.
Morning, may it please the court, Harvey Sanders on behalf of Ms. Davis. I want to touch briefly on what counsel said just at the end there about the validity of the regulation. And I would argue that the Bassett decision did in fact hold it the vaccine requirement to be unlawful and invalid. The state appealed that to this court. And at oral argument, the state said, well, we're no longer going to seek to enforce that. We're going to rescind that. And so this court never needed to rule on that. But I would argue that there is precedent for the notion that that the vaccine mandate is not lawful. And I think that's true whether you're looking at it under 557 or 2.61. And I think in my papers, I addressed the fact that I think 2.61 should apply because it's a dental clinic. But whether you're looking at 2.61 or 557,
but that's not what Supreme Court found, right? Supreme Court found that it weighed the doctor's opinion more heavily than the arbitrator did. That's right in the court's decision. The court found that this was against the interest of justice. I'm not sure where that is in the law either, but I mean, so as I read Supreme Court's decision, I basically accepted your arguments that the Supreme Court had the authority to reweigh the arbitrator's weight of the evidence analysis of reported weight of the evidence analysis of the reasonable accommodation. So that's error, isn't it, Mr. Sanders, in this context?
No, I don't think so. And I think that's what distinguishes this case from Cooper and Spence is this issue of the reasonable accommodation. And when we look at the notice of discipline, the notice of discipline specifically says the reason why she's guilty and the reason why she should be terminated is because she didn't have a valid excuse or a reasonable accommodation. And here, there's no question, the record is replete with the evidence of her request for the reasonable accommodation, the doctor's evidence, and that really bothered the court below, that the arbitrator specifically said, I don't really care what the doctor says, and that it's not relevant. And I think
The fact, this is where I was getting at with Mr. Hitchens, maybe I'm down the wrong path, but the fact of a defense or lack thereof in the arbitration is different than the weight of the arguments for the substance of the determination as to the reasonable accommodation. As to the latter, it seems to me the remedy is pretty clear under the law, Article 78. As to the former, the fact of either a defense based on reasonable accommodation or the lack thereof, that fact is something that the arbitrator can consider. And here the arbitrator said that fact does not exist.
Well,
doesn't that mean there was no error?
No, because I think the court below got it right, that the arbitrator, in reaching that conclusion, failed to consider the evidence that, in fact, there was a request for an accommodation. She had a valid excuse. If you look at the submission that's in Exhibit 5 of our petition below, there were all kinds of specific accommodations set forth. And this halo mask that was in question, I mean, this is an incredible technological mask. I mean, it removes particles that are smaller than the COVID vaccine, than the COVID particles. So wearing this halo mask would have been better than an N95 mask. It would have prevented the transmission of COVID. This would have been for the wearer of that particular mask. So there's no question that there was a reasonable accommodation, a question that would have addressed her medical issues. And that's the question of guilt or innocence here. Did you have a valid excuse for not getting it? She had a doctor's note, the doctor's testimony the arbitrator ignored, and the fact that OMH failed to engage in any analysis or explanation for it. I mean, the arbitrator said, well, that's disturbing to me, but yet gave it no weight or no consideration. And I think the court below properly found that the arbitrator's ignoring that compelling evidence was sufficient to find that there was an irrationality to the decision of the arbitrator. And so while I would agree that in the Cooper case, public policy and irrationality and interest of justice were all considered, I think in the Cooper case, the court, Judge Koliako's really, his argument was just the vaccine is unlawful, therefore I'm going to say that it's improper to terminate an employee for that. This case, I think, goes way beyond that because Ms. Davis had a legitimate reason for not taking the vaccine, and the arbitrator acknowledged, and there was evidence in the record at the arbitration to that, but the arbitrator specifically refused to consider that evidence, and I think the court below properly felt that that was a basis to overturn the arbitration decision.
Any further, counsel?
No, thank you.
Thank you, counsel. Case 433, Galt versus Nelk. One second, we're waiting for counsel. Counsel, can you hear us? You're on mute.
I can hear you. Can you hear me now?
Okay, very good. We can hear you. You just have to keep your voice up. Okay, proceed, counsel.
Good morning, Your Honors. Matt Kaiser for the appellant, John Galt. I will be relatively brief this morning. As this court knows, under its burden shifting framework for these rear end accidents, where there is a rear end accident, there is a prima facie case of negligence made out, and the burden shifts. The burden is to come forward with a non-negligent explanation for the rear end collision. And what we have here is an assertion of a sudden stop, of an abrupt or sudden stop. And if we pull back the curtain on that averment, which is contained in the affidavit of defendant Nelk, we see that there really is no factual basis for that averment. If you look at pages 295 through 296 of defendant Nelk's testimony, okay, and how much time would you say elapsed from the time you first saw the brake lights come on in the van up until the moment of the collision? No idea. We go to page 323, where he doesn't know how long his vehicle was traveling 2.5 car lengths behind the Yarlagata vehicle. He has no recollection.
Abruptness, suddenness is a function of time. It's a function of how long it was from the time of the brake application to the stopping to the collision. And what we have in this record is a vacuum.
Counselor, you said a lot of cases, but a lot of the sudden stop cases arise out of, city driving, stop and go traffic, rush hour traffic. This is the throughway. And both defendants are testifying that they're traveling right around the speed limit at 65 miles an hour. And the first indication that there's a problem ahead is defendant Yarlata, who sees the car on the shoulder, but then when he's within 150 feet or so, the car door sort of enters his lane of travel, which is what causes some of the, the slowing and braking behind him.
Right. And so you're referring to the conduct of the plaintiff.
Yeah.
And we in our moving papers, we did not move to dismiss the affirmative defense of culpable conduct.
Right.
I think
But you also didn't oppose Yarlata's, if I'm mispronouncing that, motion for summary judgment, correct?
Well, I think that if Yarlagata is entitled to summary judgment, then there's no.
No, that just to be clear, you didn't oppose his motion. So, I mean, to the extent that the court didn't grant that motion, we should grant that here, right?
Well, what I'm saying, yes. But because if Yarlagata, because Nelk testified that he didn't see anything up ahead, which I guess is something that's inconsistent with the record, considering that the only evidence in the record is that you can see a mile and a half to 3/4 of a mile up ahead, and there was really no obstruction here. It was a clear day. But I think if we were to take that position, that would be inconsistent with our argument that Nelk failed to come forward with a non-negligent explanation, because it's the conduct of Yarlagata that would supply a non-negligent explanation.
I think your position here is a matter of law. Every driver on the New York State Thruway ought to be able to stop, come to a complete stop without striking the car in front of them. No matter what happens in front of this is the trailing car, the third car in line. No matter what may happen, what may cause some event in front of whatever the lead car may do. In this case, it was a pedestrian actually who entered the thruway. That defendant, as a matter of law, must be able to stop.
No. Our position is basically that the rules of the road apply on city streets, and they also apply on throughways. And we cited a couple of cases where the throughway, which we cite Barron v. Northtown World Auto from 2016 from this court. We cite Rodriguez Johnson v. Hunt 2001 case from Third Department. The rules of the road also apply on the throughway. And if the defendant, Nelk, testifies that the vehicle ahead of him was stopped for 2 seconds, well, why couldn't he stop? He perceived what was going on ahead. The vehicle in front of him was slowing down.
That's confusing to me in this record, because Yarlata testifies, I didn't actually stop. I was slowing down when I was hit. And when he was asked at the deposition, could you have stopped if you weren't hit from the rear? His attorney instructs him not to answer that question.
Right. But the burden shifted when there's a rear ender. If anyone has to supply that evidence, it would have to be Nelk. It would have to be Nelk. The thing is, there are inconsistencies in the record, and you noted one right there as far as the Yarlagata saying, I didn't come to a stop. But there is no evidence that there was an abrupt stop, because by Nelk's own testimony, it's his burden, it's Nelk's burden of proof, because it's a rear end collision. He says the vehicle ahead of me was stopped for 2 seconds, and he can't identify any abruptness. There's no evidence as far as the amount of time that passed from the time when he saw the brake lights come on to the time of the stop. So it's our argument this morning that defendant Nelk failed to meet his shifted burden of supplying a non-negligent explanation for this rear end crash.
Thank you, Counsel. Counsel?
Yes, I would rely on Mr. Kaiser's arguments and just simply add that the lower court mentions that there's an issue as to the sequence of events, and I don't think that's the case. There is no testimony whatsoever that contradicts the sequence of events. It's quite clear that the Nelk vehicle struck the Yarlagata vehicle that was then propelled into the plaintiff and his vehicle. So that statement in the decision is inaccurate. with regard to Nelk, I would agree with Mr. Kaiser that Nelk failed to come forward with any non-negligent explanation for the rear end collision. Mr. Yarlagata testified in no uncertain terms that he saw the vehicle up ahead, the disabled vehicle. Once he discerned that it was a person pushing the vehicle and that the door, the driver's side door, was partially in the roadway, he slowed his vehicle down. He never came into contact with that vehicle or any part of the plaintiff until his vehicle was pushed into the the plaintiff and his vehicle. The lower court also mentions the application of the emergency doctrine, which I would submit doesn't apply because Nelk never even saw the plaintiff or his vehicle at any point until after the accident and all the vehicles came to rest, and he exited his vehicle and found out that there was a third vehicle involved. So there couldn't possibly be an emergency. And to the extent that the court reasons that there was an emergency, I would submit that Nelk caused the emergency by following the Yarlagata vehicle too close while, between 2 and 3 car lengths away, going 65 miles an hour in a 3/4 ton Chevy Silverado with a 30-foot RV camper in tow with a weight of about 7,400 pounds. That's all.
Thank you,
Your
Counselor.
Honors. Thank you.
May it please the court, Melissa Vinkton on behalf of defendant respondent Nelk. The motions for summary judgment were properly denied in this matter due to numerous material issues of fact with respect to the happening of this accident, including the chain of events. There's inconsistent testimony between Nelk and Yarlagata regarding the slowing and stopping. In addition, as Your Honor recognized, this is not a typical chain reaction collision on a street. This is the I-90 where the speed limit is 65 miles per hour. The plaintiff is, for some reason, because he does not remember anything about this accident, pushing a disabled motor vehicle on the shoulder of the road with no driver's license and then pushes it into traffic. We, represent that this was the emergency situation. A driver should not be expected to see ahead of the vehicle in front of it and anticipate that someone might push a disabled vehicle into traffic. There is a question regarding defendant Yarlagata and the actions he took that day or inaction that he, failed to take. There's a question of whether he could have moved to the left when he first saw this disabled vehicle on the side of the road. At no point does Mr. Yarlagata say that he ever looked to his left to see whether he could move over. Although Mr. Nelk testifies that there was no room to move over when the accident actually occurred, Mr. Yarlagata saw that vehicle before that happened, and a jury should be permitted to consider whether there was room to move over to the left at that point, and whether Mr. Yarlagata contributed to the happening of this accident by failing to move. There's a question of whether his flashers were activated, because he testifies that he turned them on, but Mr. Nelk testified that he never saw any turn signal or flashers from Mr. Yarlagata. And there's a question of a sudden stop, because Mr. Nelk testified, and there may be some uncertainty in his testimony about certain facts, but he does describe what happened coming up to that scene and the facts going up to that accident. And he testified to seeing brake lights from the Yarlagata. He slowed down. Then Yarlagata suddenly stopped completely in the lane for travel. Mr. Nelk was paying attention and traveling in a prudent manner on the thruway when he slammed on the brakes at that point to try to stop. A jury should be permitted to consider these issues, a question of Yarlagata's negligence, as well as the culpable conduct of the plaintiff in arguably causing this accident by pushing a disabled vehicle into the path of travel on the thruway. Even if Mr. Nelk was following too closely, which we submit, the evidence as presented through plaintiff's expert only considered one set of facts, and those facts most favorable to the plaintiff. even if he was following too close, it would only be some evidence of negligence. And there are multiple other parties involved here who made decisions that day.
There's a little bit of an issue here too, where the plaintiff says that we're relying on Nelk's testimony that he had 2 seconds from the time that the middle vehicle was stopped in the throughway to slow down and stop. But at the same time, there's an argument that he was within less than 2 seconds of time spaced between those two cars if he was 3 car lengths away. So question is what happened there? And then I suppose too, the question of whether or not Yarlagadda would have been able to come to a complete stop, because Yarlagadda says it doesn't answer the question.
That is another material issue of fact that a jury should be allowed to consider. It is, whether or not Mr. Yarlagadda would have struck the plaintiff's vehicle before he was even struck by Mr. Nelk. So ultimately, we ask that this court affirm the denials so that a jury can consider all of these facts.
Thank you, counsel.
Thank you.
Case 435 through 437, 2001 Inc. versus Schaefer Building Services Inc.
Morning.
Counsel, Mr. Longstreet, you're arguing today, but we have your opponents arguing virtually, I think. So we're going to wait for them to come up and we're going to make sure that you can hear each other and then we'll proceed. Perfect. Counsel, we can see you. Can you hear us?
Yes, can you hear me now?
Yeah, we can hear you now, yes.
Yeah, it sounds like a commercial.
Right, exactly. We'll wait for Mr. Oliver.
Your Honor, Miss Oliver is not in the list.
Oh, I thought he was. Or Miss Oliver, excuse me, Lori Oliver. I have listed on as arguing. My apologies. Okay, very good.
Okay. Been here a while. I'm going to just get into my analysis and focus on the facts. I know I'm certainly exhausted. There are basically two issues that the lower court, I think, just completely neglected to address. Number one, the estimates between us or the contract between 2001 and us. This started with an estimate, and the estimate, in our view, was ambiguous because it had both a warranty and a design royalty fee, which my client thought was optional, which is the reason it was set forth. We argued below that it was ambiguous because of that. The lower court sidestepped the whole issue of the estimate and us acceptance of the estimate and our signing of another contract based upon the estimate. And the court said, no, we're not looking at that. We're just looking at the invoice. The invoice didn't have the warranty, therefore there's no ambiguity. And I submit to you, the court just overlooked what we're talking about here. My client never faced this situation before, knew the warranty was optional, had no idea, and he's been in business for a long time, had no idea what this design/royalty fee was, that it was apparently some mandatory thing, and wrote another contract exactly the same with the word add on the second contract. And I submit to you, the lower court just missed the issue, just didn't consider our argument that the estimate was ambiguous, that there should have been a factual question on that and a jury determination.
Counselor, what do you make of the purchase order, though?
The purchase order with Schaefer?
Yeah.
Okay. Well, we mirrored what the estimate was. We had, instead of calling it a design royalty fee, my client called it an engineering fee, and he put next to it the word add. He thought, sincerely, and I don't think anybody disputes it, he thought it was an optional charge. But that's not the test. The test initially is to look at the face of the document and say, what does this mean when you have add? Is it mandatory? I mean, so he's in the middle. I mean, either that's ambiguous or it's not ambiguous. It's basically the same language, slightly different. And if there's an ambiguity, we get a trial on the issue as opposed to,
Hold on, counsel. Counsel Oliver?
Yes, I'm here, Your Honor.
Very good. I thought we were expecting you. I was advised that you were not arguing, and so we began the argument without you, but you're here. So have you been?
That's okay. I could hear it.
You were able to hear the argument at the beginning?
I was, Your Honor.
Oh, very good. So we haven't prejudiced you in any way. Very good.
No.
Thank you, counsel. My apologies for misunderstanding. Proceed, counsel.
So that's our basic point. We're in the middle. We're basically quoting the same language. If it's, we shouldn't be in the position of taking bullets from both sides. Either it's ambiguous and the jury finds the manufacturer that it was ambiguous, it goes our way. If it's unambiguous,
well, if it's ambiguous, then there's additional evidence that can be determined to interpret it, the parole evidence, but we never got there, right?
Well, the court got there on the second issue, but they never got there on the first issue because it basically said, here's the invoice, forget all the rest. That's our first issue. The second issue has to do with TDJ and what it did after we found out there was an issue. Basically, the owner of TDJ said, you're off the job. Well, by that time, we had already mobilized. We had been billed for the equipment. The owner wouldn't take the equipment, or the manufacturer wouldn't take the materials back. We had also done some work, some invoices, minor, $1,000 here, $4,000 there for repairs and materials to the roof. And the lower court says, basically, you didn't have a contract. Well, we did have a contract. We had a written contract that was signed. It's in the record. And this is from my memory, I haven't looked this up, but I believe we didn't send out the invoice for the engineering fee until after we were kicked off the job. The lower court says, well, when you changed the invoice, there was no longer a contract. Well, that's not exactly how it worked. And we did some work for them. So I submit, even if you find differently on the contract claim with 2001, we shouldn't have been kicked off the job, or we should have been able to recover our expenses and our damages for the breach of contract.
Mr. Longstreet, before we sit down real quick, I want to see on that cross-claim issue with TDJ that you just covered. The relief that you're seeking, is it for us to say, yes, TDJ is liable and only the amount should be determined, or are we sending it back and keeping the live across claim as to liability for breach of contract plus, if any, damages? Is it liability on the contract? Is it just damages? What is your argument here?
I'll give you the short answer. Liability, I think, should be established. There wasn't a justification to kick us off the job. And we're entitled to recover for the invoices and the mobilization and demobilization.
And that's teed up before us based on summary judgment motion?
And that's, well,
How do you get
they moved,
liability on your cross claim.
they moved for summary judgment. Right. And I don't recall what the status of the motions was, but I can tell you clearly the damages issue should be reserved for trial on the TDJ action.
Okay. Thank you, counsel.
Thank you.
Counsel Oliver?
Yes, Your Honor. Lori Oliver on behalf of MLT Leasing and TDJ Properties. This is a simple contract case. There's two contracts at issue. There's one with Schaefer and the plaintiff, 2001, and there's one with Schaefer and MLT and TDJ. Simply put, Schaefer admits in his own testimony that he made an error on collecting the engineering fee. He didn't charge my client for it. He didn't bill my client for it until it became clear that he had made that error. And the lower court rightly decided that that was not my client's liability on the TDJ matter. Once he became aware that he was being charged these additional sums, he canceled the contract, and Schaefer came and retrieved all his items. And regarding his claim for those small minor invoices and those erroneously not being considered, those weren't even part of his counterclaim. So there was no basis to consider those at all.
Thank you, counsel. Counsel?
Good morning, your honors. On behalf of 2001, there is nothing in the paperwork that indicates that the agreements were ambiguous or vague. The language in the documents are clear and unequivocal. It, like counsel just indicated, it was simply an error on behalf of Schaefer that they overlooked this fee that is due to 2001. In fact, in the testimony from the defendant Schaefer, he testified that the only reason why he didn't pay 2001 is simply because he didn't get paid from the owner. And as the Court of Appeals has held, there is no defense of pay when paid when you're dealing with contractors. The burden is shifted to the general contractor, and it should not be the burden of the subcontractors. So very simply, this is just an argument that is recently raised by Schaefer as a Monday morning quarterback to try and find some ambiguity on language that is clear and unequivocal. They put it in their own agreements with the owners on these two projects addressing our fee. It didn't come out of left field. They knew about it. They worked with 2001 in the past. And at this point, we believe that summary judgment was properly granted in favor of 2001, and the decision of the lower court should be affirmed. Thank you.
Thank you, counsel.